Mabuhay everyone. I will be discussing the part 2, the application for probation. Section 6, filing. Application for probation should be filed with the trial court which has the jurisdiction over the case. So the probationer must be submitted only to the trial court that has the legal authority or jurisdiction to handle the case or to decide the specific case. So ang probationer uh, ng masubmit lang sila only on the trial court nga may arasan jurisdiction nga ma-handle sang ila case for applying the probation application for probation. Time for filing. The application shall file his application with the trial court at the time after conviction and sentence, but within the period for perfecting his appeal and providing by the rules of court. So the probationer must may file the application only after they have been found guilty and sentenced, but they must do it within the time limit allowed by the court for filing an appeal under the rules of court. So they cannot be filed before conviction, and they cannot be filed once the appeal period has been passed. Section 8, form. The application for probation shall be in the form approved by the Secretary of Justice, recommended by the administrator, or as may they be prescribed by the Supreme Court. Official application or Xerox copy of the same may be obtained or secured from city or provincial parole. So the probationer must use only one official approved form unauthorized by Secretary of Justice, so recommended by the administrator or prescribed by the Supreme Court. They can get the original or a copy free or charged from any cities or provincial parole and probation officer. No other form is accepted. Section 9. Notice to the prosecuting officer or the filing of an application. The trial court may notify the considered prosecuting officer of the filing of the application at the reasonable time if deems necessarily before the scheduled hearing thereof. So the trial court i-inform niya ang prosecutor nga in charge sa case nga the prosecutor is ma-file for application. So this is that at the reasonable time before the hearing, only if the court thinks it's necessary. Section 10, comment. The prosecuting officer may submit his comment, if any, on the application within the reasonable time given by the court from his receipt or the notice to a comment. So after ma-receive ang notice, the prosecutor has been has a reasonable time given by the court to submit their comments or view on the application. But they are not required to submit any if they have none. Section 11, referral to proper probation officer. If the trial court finds that application is in due form of the applicants appear to the qualified for the grant of probation, it shall order the city of the provincial parole and probation officer within the jurisdiction to conduct a post-sentence investigation or PSI on the applicant and submit the post-sentence investigation report or PSIR within 60 days from the receipt of the order of said court. Conduct such as investigation with findings or recommended as State NPD 968 as amended. So if day 4 is correct, and they seem qualified, so the court kuno will send their case to the local parole and probation officer. They will conduct a post-sentence investigation or PSI, kag i-submit kuno ang report with the findings and recommendation within 60 days based on the PD 968 as amended. Section 12, Docket Book. All the records order for PSI, copies of which were received by the probation officer, shall be numbered consecutively in the order received by the said officer and recorded each docket book for a purpose, indicating therein among others the date of reception thereof, court, its branch of address, applicant's name, criminal case, description or designation of the offense, penalty imposed, and other related data information. So all the court's order for post-sentence investigation received by the probation officer, they may numbered sequentially and record in a logbook. So it must be detailed kuno, like date, court's info, applicant's name, case detail, and penalty are noted. So the court kuno also ordered the applicants to report the probation within 72 hours for the receiving order. Section 13, Effect of replaying and receipt. So the trial court may, upon receipt of the application filed, suspended by the execution of the sentence imposed in the judging or pending the submission of PSIR, PPA Form 3, and the resolution of the application for applicant may be allowed on a temporary liberty under his bail filed in the criminal case, provided that in the case where no bail was filed on the application, incapable in filing one, the trial court may allow the release of the applicant on the recognized to the custody of the responsible member of the community, who shall granted his appearance whenever required by the trial court. So the section 16 kuno is if once the court kuno gets the application, it may pause or stop the carrying out the sentence temporarily, like when while waiting for investigation for the report or decision, the application may be released on a existing bail. So if no bail or unable to post bail, the court kuno may release the applicant of the recognized under the supervision responsible person guarantees appearance. So part 3, post-sentence investigation. Section 14, assessment. After receipt the trial court, the city of provincial parole and probation officer concerned through the CCPO shall assign the same to the office clerk for docketing the eventual assessment to subordinates, investigation, probation, and parole officer for the conducting of PSI or conduct investigation himself. So after kuno receiving the court, so the probation officer kuno logs the assign the case to a designated officer who will conduct the investigation. So if the if the logs kuno has been assigned, so the probation officer kuno is mapili kung sino ang makandak sang investigation or sino ila i-designate nga police officer to conduct or to investigate.